to the eagerly awaited parliamentary debate, where we will hear rival submissions and maybe see some punches thrown on this House believes the institutional arbitration rather than ad hoc arbitration is the path forward. Without further ado, I request our debaters to kindly take their place on the stage. I call upon our moderator for the debate, Mr. Samit, founder and principal attorney at Sanctum Law, to introduce our debaters and set the stage for the debate.
Good morning, ladies and gentlemen. Thank you, Tamara, for the introduction. This House is now in session for the parliamentary debate. The motion before the House this morning is bold, provocative, and absolutely central to India's evolving arbitration landscape. This House believes that institutional arbitration rather than ad hoc arbitration is the path forward towards maximizing benefits of ADR. This is the case that the proposition will rise to champion that India's dispute resolution future lies in structured, professional, globally credible institutional arbitration. And standing firmly against them, the opposition will contend that ad hoc arbitration, leaner, flexible, sharper, and deeply rooted in Indian practice, is not merely viable, but superior. To introduce the teams for the proposition, we have Mr. Dhananjay Joshi, Senior Advocate, teaming up with Mr. Aditya Chatterjee, Partner at Keystone Partners. Mr. Dhananjay Joshi is a Senior Advocate and a seasoned lawyer with over 30 years at the bar. He has represented clients in litigations and arbitrations, as also in mediation and conciliation. His professional journey spans leading law firms such as Vadia Gandhi and Company, Amachand Mangaldas, and GSA, after which he has built a thriving independent practice focused on commercial litigation and arbitration disputes. Designated as a senior advocate by the Karnataka High Court in 2021, Mr. Joshi is frequently instructed to represent clients across the spectrum in a variety of disputes, including arbitration cases, both institutional and ad hoc. Mr. Aditya Chatterjee is a partner at Keystone Partners, Bangalore, and specializes in complex civil and commercial litigation and is recognized for his counsel work in both international and domestic arbitrations, institutional as well as ad hoc. He's frequently engaged to lead cross-examinations in high-stake court trials and arbitral proceedings. A graduate of GNLU and UC Berkeley, Mr. Chatterjee is additionally qualified to register as a solicitor in the United Kingdom and holds rights of audience as counsel before the DIFC courts in Dubai. For the opposition, we have Mr. C.K. Nandakumar, Senior Advocate, partnering with Ms. Neha Nagaraj, partner at Frontline Law Partners. Mr. C.K. Nandakumar is a Senior Advocate designated by the High Court of Karnataka in 2021. Mr. Nandakumar regularly appears before the courts and tribunals across India in matters involving corporate, commercial, and arbitration law. Mr. Nandakumar is known for his keen ability to simplify complex commercial matters and result-oriented strategies in litigation matters. Mr. Nandakumar is a member of several leading arbitral institutions across the world and is a fellow of the Chartered Institute of Arbitrators. Ms. Neha Nagaraj is a partner at Frontline Law Partners, a boutique dispute resolution firm in Bangalore. She is a skilled litigator, arbitrator, and mediator specializing in complex commercial disputes. She has further distinguished herself by becoming only a handful of women in India accredited by the Chartered Institute of Arbitrators, United Kingdom, as a fellow and accredited mediator by CEDR and an IMI certified mediator. She also serves as an external member of internal complaints committees for domestic and multinational companies, conducting investigations on sexual harassment complaints and advising on POSH issues. The structure of today's debate will have both the teams alternating between the speakers putting forth their arguments, followed by the rebuttals, after which we will request the audience too to put forth their questions to both the teams, and thereafter, one speaker from each side will present their closing arguments. We will then end the debate with the all-important audience vote. To begin with, we will take a preliminary vote by a show of hands, which reflects the House instinct before hearing a single argument and, more importantly, reveals just how much the debate shifts you. So may I see a show of hands for those in favor of the motion today? And those against the motion? Quite less. I think the opposition has a tough job today. The baseline now has been recorded. We now move on to the arguments. To open the case for the proposition, Mr. Dhananjay Joshi. So the floor is all yours.
Good afternoon, ladies and gentlemen. Good afternoon. The motion as it reads, institutional ADR rather than ad hoc ADR, is the path towards maximizing the benefits of ADR. The question that looms up is maximizing the benefits of ADR for whom? We have several stakeholders. There are lawyers in the ADR process. There are arbitrators in the ADR process. And I see only lawyers and arbitrators in this audience here. Are we going to debate the benefit of the ADR process for us or for the main stakeholder, that is a litigant? The ADR process is intended to benefit the litigant primarily. Therefore, the motion ought to read when it's complete that whether institutional ADR is preferable to ad hoc ADR in terms of benefit for the litigant. Because when we look at ADR as a process, it is a justice delivery mechanism. There's nothing so unique or different or separate about the ADR process. It is a justice delivery mechanism. In this justice delivery mechanism, as in the courts, the lawyers and the arbitrators work equally sincerely, put in the same amount of effort. So there's no difference in the ADR, justice delivery mechanism as an ADR or as a court. But then what is the difference between the two processes for the litigant? For the litigant, we would look at three factors. When a litigant comes before a justice delivery system, he would look at three factors: costs, time, and reliability. When we look at costs in the ADR process, institutional arbitration provides expectation of costs. It provides pre-knowledge. There is a fixed fee schedule. Therefore, a litigant knows that this is what I'm getting into in terms of costs. But that is not so in terms of ad hoc arbitration. In an ad hoc arbitration, the litigant will come to know of the costs at the first procedural hearing. And then it becomes too late. Because often they're caught by surprise at the fees quoted by a tribunal, because it is a tribunal that decides the fees at the time of the first procedural hearing. And this catches them like rabbits in front of the headlights. They don't know what to do. Protocol will not allow them to get up and say, no, this is not acceptable to me. And they're stuck. And that is a fatal flaw in ad hoc arbitrations, because it takes away party autonomy. The party is no longer autonomous in choosing its forum because it finds that it is trapped before a particular forum. And that is the trap which institutional arbitration helps avoid. This, until very recently, used to be an issue, that costs being fixed by the arbitrators. In a judgment that came up in the Supreme Court, ONGC versus AFCONS in 2022, 30th August 2022, if I'm right, that is when one of the parties to an arbitration, being of course a corporate, and it had the gumption to stand up to an arbitral tribunal and say, no, what fees are being fixed by you may not be acceptable to us, may not be appropriate. This issue came up before the Honorable Supreme Court, where the Supreme Court said that costs cannot be determined by the tribunal on its own. It has to be determined by the consent of the parties. And that is where institutional arbitrations is way ahead of ad hoc arbitrations. That was one factor. The other factor we should look at is time. we have seen so often that ad hoc arbitrations just go on and on and on, whereas institutional arbitrations provide oversight. Institutional arbitrations, there are the institutional mechanism to say that this is the time frame, there is foreseeability, there is an expectation of how long the process will take. While in ad hoc arbitrations, that is no longer that is not so much in control. Section 29A to an extent is a remedy. It does provide some sort of a check on prolonged arbitrations. But even then, what does Section 29A lead to? Either termination of a mandate or extension of time, periodical extension of time for the tribunal, neither of which helps the party. The party still suffers because of the delay and the costs. So 29A is not a panacea for ad hoc arbitration. Institutional arbitration remains the answer as compared to ad hoc arbitration. Lastly, we come to reliability. Reliability of an arbitral award is, I think, the core factor for any justice delivery mechanism. If an arbitral award is doubtful, it does not withstand scrutiny, it does not help the process. If eventually, having gone through a process of arbitration, an award is easily set aside because it falls afoul of Section 34 or 37, it is a waste. And given the jurisprudence of arbitration, because once an award is set aside, if not on merits, then you have to restart the arbitration all over again. And we have seen this, and I'll just close with this. Our Chief Justice also on Friday, when during the inaugural address, spoke about reliability of awards and quality of awards, where he mentioned that institutions provide oversight in terms of research assistance. For example, our Bangalore Arbitration Center also has research assistants which help the arbitral tribunal to improve the quality of awards, which facility is not available. I just end by this. It is like this for a party. When you go into Vidyarthi Bhavan or when you go into a Michelin-starred restaurant, the taste is known, the cost is known. There is an expectation of what you will get. You walk into an unknown restaurant, the cost is a surprise, the taste is a surprise. Justice cannot be surprised. Predictability of the justice delivery mechanism is what will ensure its success. Therefore, institutional arbitration is the way forward. Thank you.
Thank you. Can we now have Sneha to open the arguments on behalf of the opposition, please?
I'd request my panelist, Ms. Neha Nagaraj, in the spirit of women in arbitration, to go first. And I note that my learned friend, speaking for institutions, disregards institutional timeframes.
Respected judges, distinguished members of the bar, and my dear friends, I'm not here to say institutional arbitration is bad. I'm here to say something harder and more honest. We are institutionalizing arbitrations, yes, but not in the direction that serves the parties with the right interest. And until we fix that, ad hoc arbitration may have some flaws, is still the lesser of the two evils. The process, the people who are running the institutions today are not the problem. The process is the problem. The process has not caught up with the ambition of where we want to head in terms of arbitration. Arbitration was created to be flexible, to give parties their right to frame rules, timelines, procedures, and who they want to pick as an arbitrator. The heart of arbitration is party autonomy. But in India, institutional arbitrations, they've grown in a way where this autonomy is completely out of the room. There is another truth we must face. Our institution system today leans towards the claimant, and I'm very mindful of what I'm saying. Not because anybody wants bias, because the economics of the model pulls them in that direction. Think about it. Institutions earn fees when the case continues. Claimants want the case to continue. And arbitrators who are banking on appointments by these institutions, they know that if they close the case too early, too firmly, or too independently, they won't get reappointments. Now, this is not malice. This is an incentive problem. You don't want to bite the hands that feed you. And you can most clearly see this in Section 16 orders. Now, let me tell you something even more serious. Key decisions that have a fundamental impact of procedure and fairness in an arbitration are masquerading as administrative decisions. And I'm not, again, saying this lightly. Institutions today are closing pleadings. They are declaring that the records are complete. They are taking a call or pre-deciding that that an arbitration should be a documents-only arbitration without the consent of parties. And I want to give you an example that I have faced in my own experience as an arbitrator. In one of the cases where I acted as an arbitrator, I knew that oral evidence was necessary. Yet the institution said, no, this is only a documents-only arbitration. And the decision was taken at the very beginning without the consent of respondents. Now, this is the core problem. Complete breakdown of procedural justice. This is not how institutional arbitrations the world looks at or the world understands to be. But this is how institutional arbitrations have devolved in India. And until we course correct, ad hoc arbitration simply remains a safer option. Now let me come to appointments. In India, appointments depend on the case claim or the claim value. If it's a 20 crore claim, then you have retired judges. If it's a 20 lakh dispute, then you have some junior lawyer. No one is wrong here. Institutions have to manage volume. And the effect is, today we have a tier-based ADR system. Claim value rarely reflects complexity. And we all know, a small contractual dispute, which is helping build technology, may require far more expertise than a large supply contract. But the tier system does not allow this. And this is where ad hoc arbitration gives you something that institutions don't. They give you a voice. Where parties don't agree to an arbitrator, you file a Section 11. The court gives notice to both parties are heard. At least there you can go before the court and say, this is my dispute, this is the kind of arbitrator I want, this is the kind of expert I want, kindly help. And the courts give you this. This may not be perfect. Yes, time may be an issue, but at least it is transparent. Party autonomy is maintained. But institutions do not do this. Appointments happen behind closed doors. Parties don't know who's getting appointed. Parties don't know why. Parties don't know if this arbitrator is suitable for their dispute. But they're simply told, this is your arbitrator. This is a very different kind of opaqueness. And this opaqueness is definitely not neutrality. Institutions have grown without safeguard that courts give us. Until institutions in India build that kind of transparency and trust, Section 11 remains a safeguard, not a bottleneck. And today, to convince you all, the points are extremely practical. We all know how arbitrations are being done today. Government has withdrawn from arbitration because of this fundamental issue that institutions are clearly mocking them with arbitrators, etc.
Thank you,
Sorry,
Sneha.
last point. But I genuinely hope that we reach a place one day where we want to promote institutional arbitration. But today is not that day. Let's look at what's happening today. And until that day comes, ad hoc arbitration may not be the perfect choice, but is definitely a better choice, the choice that keeps the heart of the arbitration alive. Thank you.
Thank you. Can we now have Mr. Aditya Chatterjee to continue the proposition?
Distinguished dignitaries, and let me start with a word of gratitude to a wonderful institution that has conducted a wonderfully institutionalized debate with rules and timers and bells and moderators and a fantastically organized audience. Thank God we are not trapping ourselves in the ad hocism of ad hoc debates. I must confess, with a panel like this, I'm the worst representative for the proposition. We have retired judges, senior counsels who are touring the world with the most coveted of arbitration appointments. I heard the introductions being made, and the first speaker for the proposition was introduced as a member of the CIRB. Don't see her resigning from that. There are senior counsels who have, and it's true, reported, who have been members of the CIRB for so long. There have been members of the there have been certified arbitrators from the Institute of Arbitrators. invited to ICC Advanced Arbitration Academy, India's advisor to the committee of the ICDR, invited to Bali as the International Center's representative. And not only in India, in Hong Kong, the HK45 has said, you come and help us run the arbitrations in Hong Kong. Next time you must look for more distinguished speakers than I can be. If only I had the name. Mr. C.K. Nandakumar. To quote Hogwarts' best headmaster ever, you can't be scared of the name, you'll be scared of the thing itself. Don't be so scared of institutions. We've had it all the time. Can an arbitrator run an ad hoc arbitration by himself? Absolutely. Can 100 arbitrators run ad hoc arbitrations with perfect timing and perfect decorum for the litigant? Absolutely. But there's something that transcends the individual in the ad hoc arbitrator. That is memory. Institutions outlive the individual. Institutions have a memory of their own. They carry an experience into posterity. Do you remember the ad hocism of monarchical justice? We reformed that. The king is not the representative of divine justice anymore. What did we move to? An institution, the court. We are all here benefactors and owe our profession to institutions. That institution got stretched at some point, and we arrived at an alternative. So arbitration was the solution to an overstretched litigation system. Institutional arbitration is the solution to a nascent arbitration system. We cannot miss the woods for the trees. And what the proposition is today saying is that if you have a headache and there's some problems that you have encountered with institutions, chop the head off. The correct answer to institutional problems are more institutions. Let there be a competition between all the Hong Kong, the Bali, the ICDR, and the Bangalore-based arbitration systems to vie for your litigants' custom. The true test is not to say because they have some chinks in their armor, let's get rid of them all, let's have ad hoc debates, let's run our time on the bell, let's not have a moderator, and let's decide what the proposition is, and I'll stop there.
Can we now have Mr. Nandakumar to
Good afternoon, respected members of the audience and my esteemed colleagues on the panel. I will take what fell from my esteemed opponent as, I don't know if I should take it as being ironical, but even if it were, I'll say that it's because of what I've seen and in spite of what I've seen that I'm saying what I'm saying. So thank you very much. Secondly, I think he's gotten ad hoc mixed up with chaos. 4 out of the 5 letters of the 2 words are pretty much the same. Anybody who does that, and I'm going to take a cue from Mrs. Anand Reddy in the earlier session, institution leads me to think of institutionalization. And therefore, that's one more reason not to go with it. But jokes aside, and on a more serious note, let's look at what really we are trying to do and what it is that we're trying to say. The question before the House today has been completely missed by my esteemed friends from the opposition. The question before the House today is not whether or not arbitration is better than litigation or should there be arbitration or ADR at all. And I think that's really what they've spoken about. The question is institutional arbitration the road forward as against ad hoc arbitration for maximizing the benefit of ADR? Now, what is the benefit of ADR? The benefit of ADR is that it eases the burden of the court system. The benefit of ADR is the trifecta of ensuring time, cost, and efficiency. Is that best done with institutions? The obvious answer to that is no. In India, what is it that we talk about? And I think this is a part of the problem. And having been through all the international conferences and those institutions, I can tell you, what we are trying to do in India is to blindly bring in a system that has been perfected abroad and without trying to even use a little bit of imagination, import it into India. It works in Singapore. Why shouldn't it work in India? Well, Singapore has the population of Jayanagar. That's the fact of the matter. India has more cases than Singapore has citizens. India has 10 times more cases than Singapore has citizens. You still want to import the same system? This is really the problem. The problem is not how, or the fact that institutions work abroad. The problem is how they work abroad and whether they're best suited to India. And the short answer to that is obviously no. If you want to make a change to a system, please do it. And we are all welcoming it. Nobody is saying no. The question is how one has to go about doing it. The other aspect, and this is something that my esteemed colleague pointed out, there is a degree of self-perpetuation which happens when it comes to these institutional appointments and arbitrations. It's, there is a portion of what keeps going and the people who are the same participants in these institutions time and time again. So therefore, that is another aspect that definitely bears consideration. The third thing, and one thing that we keep mixing up, I am a fellow of the Chartered Institute of Arbitrators in the UK, but it's not necessarily run as an institution. This is an important distinction. There is a difference between an arbitral institution and a center that provides infrastructure. We cannot mix the two up. And if you have mixed the two up, that can't be you speaking on behalf of institutional arbitration, because you fundamentally misunderstood the two. Institutional arbitration are institutions such as SIAC, ICC, which have a global standing and are willing to run at the global pace. And who do they cater to? Large global corporations primarily. Is it possible for a litigant who has a lease dispute insofar as a commercial shop which has an arbitration clause to go to ICC? Is that institutional arbitration feasible? Is it practical? Of course not. There is another aspect to this, which is that these institutions, though they may be non-profit organizations, they run on the fact that people around them there is an economy and a whole ecosystem that runs around that. That is something that we can't lose sight of. Now, is that done? Right. So with that, I will largely make the point that we are missing completely the point that needs to be understood, which is that ad hoc arbitration in India has worked. It certainly needs more reform. That reform, which is already there in the Arbitration Act, all it needs to be done is to have it implemented. And for that, we have courts which are overseeing that process, which is far better than private companies masquerading as arbitral institutions, being let loose on litigants, and then wishing and praying to God. And then in 5 years, we all come back and say, no, maybe Nandakumar was right after all. We should not have gone down that road. Thank you.
We've had quite a feisty introduction and certain arguments from both the ends. Can I now invite Mr. Dhananjay Joshi to go forth with the rebuttal?
Won't take me 2 minutes to answer him, that's all right. Mr. Nandakumar ended his talk by saying that the Act is providing for the framework for giving a solution to all the problems. Precisely. The Act is indeed providing the framework. The 2019 amendment to the Arbitration Act provides for institutional arbitration in this country. We are learning from the lessons from abroad and bringing in the best practices into this country. If we were to have hundreds and hundreds of disputes, the answer is not to have that many ad hoc arbitrations with no strict rules. Party autonomy is lost. Whereas when we bring in these rules, when we bring in this framework from abroad and the best practices from abroad, that is when arbitration as an ecosystem will succeed, will flourish. Because I repeat, predictability, history, a repository of what has happened in the past is essential for justice delivery. Every justice delivery mechanism cannot come as a flip of a coin, for example, or a toss of a coin. We don't know what the arbitrator might do. We don't know what the costs are. We don't know how long it may take, whereas institutions provide this oversight. And therefore, to say that we cannot have institutional arbitration because of the sheer population, that our country is much larger than the population of Jayanagar. Therefore, we need institutional arbitration where there are rules. The other point that was made was we seem to be mixing up with infrastructure and framework. No, we are not. Certain institutions provide the actual infrastructure, like, for example, the Bangalore Arbitration Center seeks not only to provide the framework, but also the infrastructure. That is Bangalore. Here, an ordinary lease dispute for a simple office space in Jayanagar can also come in for arbitration. It need not be expensive. It need not be prohibitively time-consuming. And therefore, an institution like the Bangalore International Center is providing yeoman service in bringing in institutional arbitration into the city. On the other hand, if we say that we can only provide the framework and not the institution, that also is possible. Nobody says that the rules which are promulgated by the Bangalore International Center cannot be adopted by an arbitrator sitting elsewhere at some other venue and say that we will do this according to the rules framed by this institution. Therefore, it is an evolving landscape, and the evolution is towards institutional arbitration, as has been shown by Parliament by bringing in the 2019 amendments, which have to be notified yet. Therefore, institutional arbitration is the way forward. Thank you.
Can I now invite Sneha for her rebuttal?
I was really hoping to hear some rebuttal points to what I said from Learned Senior Counsel Mr. Joshi, but I got nothing. But however, I have jotted down what he said, and let me rebut on those. There were 4 factors that he spoke about. One is expectation of cost. Really? Parties today ask me, why are we paying admin fees? What is this institution doing? We're not looking at ICC and SIAC here, but we're looking at small disputes that happen on a daily basis. Parties saying, why should I pay? What am I getting? What service am I getting? I'll get venue at a cheaper rate. Why am I paying this admin cost? So, expectation of cost, I disagree. There is no proportionality of cost. Every institution that's set up today is going and organizing seminars, putting out their logo, publicizing their names, because they want large MNCs to recognize them. That's become the game. Profiteering, that's the motive. So there is no expectation of cost. And party autonomy. He says there is party autonomy in institution. Are you serious? I don't even know. Government is withdrawn from arbitration because they don't even know who their arbitrator is going to be next. They don't know what they're getting into. Even though party autonomy is the heart of arbitration, nobody today is getting to choose anything in an arbitration, and the whole system of arbitration, which is in party autonomy and rooted in party autonomy, is today collapsing because of the way institutions are conducting themselves, and that is the issue. He spoke about time, saying in ad hoc, you can't predict time. Well, he also answered saying there is Section 29A, and I think today, because courts have taken much more sterner decisions in terms of implementing 29A, arbitrators are also serious. Arbitrators are not giving you timelines today saying, yeah, let's exceed. Every arbitrator today is conscious about 29A, so timelines are being implemented much more strictly than what it used to be. Last point, reliability. Are institutional arbitrations really doing award scrutiny today? If institution arbitrations were doing award scrutiny like the ICC and SIAC, government wouldn't be withdrawing their mandate from arbitration. I rest my motion. Thank you.
Can I now have Aditya to lead his rebuttal?
There was no arguments which said that ad hoc is better, we should get rid of institutions. Their entire argument has been, institutions have problems. That's like saying democracy has problems. But their argument will never be that get rid of democracy. The answer to every argument that they brought is more institutions, more competition among institutions to say that we will be better than the previous one was. And the argument on costs, predictability and autonomy, they lumped it up into one. When was the last time you went to adhocarbitration.com and saw a schedule of fees saying this is what you'll pay? high or low. You didn't know it until you first went for the first procedural hearing, where there's a 2-column table, the most scary a litigant can see. Today, with all its faults, institutional arbitration tells you what you will expect. It tells you this is going to happen. If it is not going to happen, you can question it. Ad hoc arbitration has its benefits for the arbitrator, for the arbitration practitioner. It is a candid truth we should admit in very hushed voices. But if we are asking, is the future of arbitration for the litigant better in ad hocism or the institution, we only have to look back at history. Litigants have picked the institutions. We need better institutions. The example cited of what we are not doing is that today it is not happening like it's happening in ICC. It is not happening, it's not like it's happening in SIAC. My argument is in your answer. We need those ICCs in India. We need those SIACs in India. One line in response to all their arguments is the best way to predict the future is to create the future ourselves. We don't have to rely on ICC. We don't have to rely on SIAC. It can happen here in Bangalore. Many institutions, one even in Jayanagar. Thank you.
We finally found something we can agree on. That the best way to predict the future is to create the future. To create the future is not to go and make the same mistakes that the world made. I was going to take another poll if the moderator would have permitted me. How many people, other than the Karnataka Arbitration Center that we have in Bangalore, can name arbitral institutions in Bangalore? Anybody? I didn't think so either. And I think that's pretty much the point I was trying to make. What credible institutions do we have today in Bangalore? Today, Bangalore is the 3rd largest economic center in the country. What credible institutions do you have here? Now, my esteemed friend, Mr. Joshi, started by talking about who does it benefit. Now, the whole point that he made really is a debate between litigation versus ADR. It is not a debate between institutional ADR versus ad hoc ADR. And insofar as fees, they said, oh, you'll be surprised, deer in headlights. On a lighter note, I hope that's not the case with litigants coming to Mr. Joshi. But jokes aside, I don't know of adhocarbitration.com when you go and then learn for a surprise, but I do know there is a Bear Act in front of you, Mr. Chatterjee, on the table in front of you. Page 54 has something called the 4th schedule to the Arbitration Conciliation Act. It is cast in stone. You don't need to go too far, so you don't need to feel surprised. Also, it's a very simple thing. When clients come to a lawyer, they invariably ask you what your fees are. When lawyers ask arbitrators for their appointments, when they're taking their consent, and nobody makes appointments in ad hoc arbitration, unlike in institutional arbitration without consent, when you do so, we very often have the conversation about fees as well. So when that is so, to say that you are surprised causes me surprise, because you shouldn't be. Then, the next aspect is that of today, the fact that the Parliament has found it necessary to introduce amendments to bring in institutional arbitration. Well, yes, even the Parliament has thought it necessary to regulate arbitral institutions. And guess what? That's not yet been notified. So today we have a situation where the Parliament thinks our institutional arbitration needs regulation because it's running amok. But even that has not been notified. And yet, they swear and tell you, stick to it. Good luck. Well, maybe in 10 years, it may get better. Till then, stay on an arbitration and then see. But that's exactly what we're saying, don't do. We are saying, till such time that there is something better, till such time that there is something more reliable, ad hoc arbitrations, there is really nothing much wrong. Have there been something wrong that has gone on? Nowhere close to what has gone on wrong in arbitral institutions. So therefore, ad hoc arbitrations. Now the problem is this: if you don't have good arbitrators, good counsel, that is not a fault of the system. That is even more marked in institutional arbitrations. So let us not have a situation where we, instead of introspecting, are pointing fingers. And that's pretty much what the opposition is. Thank you so much.
thank you to all the four of them who have presented their arguments and sites. Now, we'd like to take some questions from the audience for both the sides. If we can start with questions for the proposition team. Anyone has a question?
So I have a question around like we portraying as a global arbitration hub, where the government tells that we are a global arbitration hub, and now we are talking about institutionalization of the arbitration and having ad hoc arbitration. How do we stand with respect to our goal or vision being global arbitration hub? Well, in this arguments or rebuttals, I could not see the coverage on this. Could you show highlights on that?
That is indeed the path towards our institutional arbitration. When we say that we want to become an arbitration hub, global, domestic, doesn't matter. The objective is to provide an effective ecosystem of arbitration and ADR to relieve the courts from the burden of litigation. That is the objective. There is no label, there is no prize waiting for us at the end of the path. All that we are striving to do, Parliament and we as the stakeholders, is to provide an effective alternative dispute resolution system. And that, to achieve that, we have to necessarily take the burden away from the courts and provide it by way of institutional arbitration and not ad hoc arbitration. That is what Parliament is working towards. That is why the 2019 amendments have come in, and that is where we are heading. It is not today. The journey has not ended. The journey has begun. The journey, it is an evolution that is taking us forward, and the mistakes that the institutions are committing will, with experience, keep improving and changing, and that is the evolution that we're looking at. That is where we will become an arbitration hub, not immediately overnight.
I was going to say you've asked the wrong side of the hall the question, but still.
And do we have any questions for the opposition team as well?
Well, talking about institutional arbitrations versus ad hoc arbitrations, we have a kind of a few institutions that are presently operating. One of them is the High Court, which appoints arbitrators. If you had institutional arbitrations or more institutional arbitrations, as Mr. Aditya would tell us, then a person who wanted to choose an arbitrator would not be stuck to an existing panel of arbitrators and the existing rules of the Bangalore Arbitration Center. He would get to choose from multiple sources. So where parties can't agree upon an arbitrator, and therefore you can't, in that sense, exercise your party autonomy, isn't an institutional arbitration the need of the hour?
Thank you for that, Mr. Arun Kumar. Actually, I think you pretty much made the point that we are trying to make. Today, you don't have necessarily credible institutions, at least in Bangalore. Now we're talking about the context that we are in today. What the High Court has been doing in your Section 11 petitions is really to try and institutionalize what is otherwise ad hoc arbitration. Just another minute on this, which is that normally what happens when it comes to institutional arbitrations is that parties would have in their contract, well prior to the dispute, agreed that if there's a dispute, they'll go to SIAC, they'll go to ICC, they'll go to LCIA or whosoever they've chosen. That's not the case in most contracts in India, and this is the fact of the matter. The fact is that till such time that you have the power to appoint being given to those institutions, this process is not going to be popular enough in India. This is a fact of the matter. You also don't have enough people saying that they want the Karnataka Arbitration Center to appoint in their contracts. You don't have, let's say, for example, me and him entering into a construction contract where we say that, all right, I'm agreeable to the Karnataka Arbitration Center appointing. So this is a fundamental point. If that is so, then equally true is the fact that the Karnataka Arbitration Center has some limitation in as much as it has a list or a panel of arbitrators from which it chooses. This also means that you don't have party autonomy. Suppose you thought for, let's say, hypothetically, a construction dispute or a very complex IP dispute, you want somebody who's a domain expert, let's say, for example, a a Bitcoin dispute, you want somebody who's a domain expert in that. It could be a law firm partner who's probably best suited for it. You would lose out on that if you went and filed your Section 11 or you asked any institution around, because there is no agreement on an institution. You can't at the point of dispute go and have that agreement. This is exactly the problem that we are trying to highlight. Whereas if it were ad hoc arbitration, which let's say your agreement does not have an institution named, you could choose the best person for the job. And that is the important difference that ad hoc arbitration offers you today, which institutional arbitration today in Bangalore is not offering.
I just want to add to what Mr. Nandakumar said. I think I'm just trying to propose a solution here rather than, just speak about the problem that we're currently in. Now, party autonomy truly is not being practiced, whether it's ad hoc or institutional arbitration. But if institutions are the way to go ahead, why don't institutions consider, because in most disputes, both parties will never agree to an arbitrator. Why don't institutions consider a situation where each party at least gets to state what kind of an arbitrator they want for a particular dispute? And that is probably submitted before the registrar or the president, who then makes a sound decision. But also to complement the sound decision, you need a good panel of arbitrators. I think that is seriously lacking in our country today. And I feel like these are the two things that we need to address. One is a good panel of arbitrator, and one where institution actually tries to draw up a process to retain the concept of party autonomy.
Do we have any more questions from the audience?
I have a question for the speakers who are speaking for the proposition. This is specifically in relation to challenges arising on apparent bias of arbitrators. Referring to the rules of the SIAC, ICC, LCIA for that matter, they have specific provisions which say that any decision that is rendered by the ICC court or the SIAC court on challenges shall be final and subject to no appeal whatsoever, right? When you have a party that is expressing an opinion on bias, claiming that an arbitrator that has been appointed either by the institution, which again, parties on most occasions have no choice when there is a dispute. When institution-appointed arbitrators are put in place, parties allege bias, and you have a virtually private court comprising of some practitioners who you have no visibility on making decisions, and again, who are subject to no appeal. How does then that go to reinforcing some sort of faith in an institution which is supposed to protect your interests, right? We've had a situation wherein parties have come all the way from Singapore to the Delhi High Court in engineering projects seeking an anti-arbitration injunction because the ICC tribunal continued with the arbitration despite apprehensions of bias. These go to the root of institutional or the promise that institutions provide to protecting the integrity of the process. How would you respond to these allegations?
Yeah, thanks. I'm stepping aside from which side of the proposition I am. I must tell you that even there, the way forward is institutions. Because all the tests that we have in our act that protects even ad hoc arbitrations is drawn from the orange list and the red list of the IBA guidelines, which more or less every successful institution has now adopted. And the reason I feel for bias-related scenarios, you can't look beyond. Institutions will be the starting point. It's going to be a question of which institution is better and more transparent and has a larger panel. LCIA, for instance, and I'll tell you from an example that I was involved in, one LCIA arbitration and one ICC arbitration. The unique feature of these two institutions is that they have a list of all arbitrators who have previously been found to be disqualified on bias. You also have a list of how often the LCIA has removed someone on grounds of bias. They've redacted the names, they've redacted the parties, but the rationale and the percentages are all there. Institutions do further the cause of transparency far more than ad hocism ever will. It's only about finding the right balance, how far we can push this, and I genuinely believe that the answer to this is competing institutions, where one institution competes with the other to be more transparent, to be more litigant-friendly, and to be more futuristic in allowing for the kind of disputes that can be resolved.
Again, can I just partly answer that from a different perspective? I mean, I'm not getting into the debate of institution versus otherwise. There's an important point that actually you have to look at. Your guidelines on conflict of interest, for example, that the IBA came out with. IBA is not really an arbitral institution. It's an organization, non-government organization, which has come up with some sort of a regulatory mechanism or a self-regulatory mechanism for the bar and the arbitration community as a whole. So you have to be careful when you look at what you mean by an arbitral institution. The second important point is that you have institutions like SIAC or ICC, and this is pretty much the point I was making earlier as well, which have had years of experience, right? In the case of ICC, it's been over 75 odd years or whatever it is. And in the case of SIAC, it's been around for 30 plus years. Now, what they have is that they've been able to develop databases and store it. Now, the fact of the matter is that we have no such thing, as far as I can tell, in India. Maybe the newer institutions are making an attempt in Delhi or in Hyderabad, but I don't know of any such attempt at all here. Now, this is therefore leaving you with a situation where, irrespective, the safest recourse you have is under the Act. And that's pretty much what you're left with. That's the way I would look at it as far as at least Indian context is concerned.
I think we have one more question.
Yeah, thank you for the wonderful arguments. It was very entertaining and same time it was very educating. So my point of view is that it's not institutional arbitration versus ad hoc arbitration, but it should be institutional and ad hoc arbitration should be there. It should go, both should be there. It's for the parties to opt for which one they want. And then again, I stand in favor of ad hoc arbitration. Why? Because say you are saying it is an alternative to the court, and in a way you are creating a court if you say it is an institutional arbitration, because litigants want to come out of the court, and this ad hoc is like they choose the parties, they choose the procedure, right? And again you are creating a court outside the court in the form of institutional arbitration, again makes the parties to question, and say that procedural encumbrances that is there in the court would gradually flow into the institutional arbitration is my point of view. Thank you.
Thank you, everyone.
Institutions don't adjudicate. Institutions only provide the framework for enabling arbitration. So when we talk of institutional arbitration, we are not talking of institutions conducting the arbitration. Institutions enabling the arbitration is what should be the right perspective. They provide the framework, they guide the arbitrators. In fact, the research assistants at the Bangalore International Center are simply fabulous. The way in which they have assisted the arbitral tribunals, some of the research assistants have gone on to become presiding officers also, judicial officers also. They're that good. And that advantage is missing in ad hoc arbitration. When in an ad hoc arbitration, when the arbitrator draws up the award, he does it with all sincerity. The objective here or the point is not that we are dissing the arbitrator or the lawyer. The stakeholders are the same. It is the enabling framework that makes it more efficient for the benefit of the litigant. That should be the perspective.
So if I can just quickly offer the counterpoint, which is very, quite simply stated, is this. The Supreme Court has held that the function of a court in appointing an arbitrator under Section 11, for example, is a judicial function. It used to be seen as an administrative function. It no longer is and hasn't been for many years. Insofar as appointment of an arbitrator, in which in many ways is at the heart of party autonomy and therefore really at the heart of arbitration in many ways, you are saying that I don't want to go to court and then I don't know who's going to hear it when. Therefore, I would rather say, for example, Dhananjay is a great arbitrator, I'll go to him and I'll have him resolve this dispute, and he's known for his fairness and so on and so forth. That process of appointment and decision-making around the appointment, you are ceding to an institution. So therefore, there is, I don't entirely agree with him when he says that there is no decision-making at all by the institution. There is an important aspect of decision-making which is to decide your fate on who your arbitrator is going to be, he or she, at and by the institution within closed doors in some senses, often disregarding party autonomy. Because you might have a pick, if that isn't accepted, it's the same process, but the appointment is then done by the institution and not by the court. That is an important distinction to bear in mind.
Thanks. May I invite one person from the proposition team to close their arguments? Quick 2 minutes, please.
To close this argument, George Orwell would have said it's always a struggle to see a solution that's right below your nose. The answer is in the motion. The dictionary definition of ad hoc is temporary, uncertain, arbitrary, vague. And if the motion is this the way to maximize something for the future? I'm pretty sure the answer to maximize something for an ever-ending, everlasting future can't be temporary, uncertain, vague, arbitrary. Every argument that the opposition has made is only a modicum of getting close to say we are not ready yet. Why are we not ready yet? Because we don't have those institutions yet. Will that be the solution once the institutions come? They don't seem to have a disagreement with them because they have quoted profusely from jurisdictions where those institutions have worked. The unfortunate thing about experience is it's a measure of time. Unless you start now, there is no future. Will today's institution be perfect? No, it'll have all the problems that the opposition pointed. Do we have evidence that these institutions have worked and history to stand testament to that? Yes. And we as lawyers should be the first to recognize evidence. And if it finally comes down to saying, are you then arguing for a perpetuity of ad hocism? I take a point from the lady's question. When we say institutional arbitration is likely the best way to maximize returns for in the future for the litigant, it doesn't mean ad hoc arbitrations will go away. It never can. Let's remember, every time a litigant is trying to approach an institution, even the court for that matter, they have gone through several levels of ad hoc within the family, well-wishers, extended family, business partners. All of these are variants of ad hoc, and they don't want that to be replaced by an ad hoc arbitrator. You need institutions, and that's where we rest our case. Thank you.
I've understood the problem. It is that we are advocates and they're astrologers. We are looking at what the situation today is, and they're saying, you have a great future in 20 years, don't worry. I ask myself, the stakeholders who Mr. Joshi referred to, the litigant, is he ready to wait for that 20 years? That is the question that I ask myself, but the answer is obviously no. He said ad hoc means temporary, it means arbitrary, he said all of that. But do you know who coined that term? Institutions. So therefore, you coin a term, diss it, and then say, see, I'm better than that. This is no solution. The fact of the matter today is that what we are faced with is a situation where your average person does not, if we are going by what Mr. Joshi began by saying, access to justice. Do we have access to justice if we merely believe in institutions today in India, which are practically, I asked, who can you name an arbitral institution in Bangalore other than the Karnataka Arbitration Center? The answer is no. Do we have access to that? The answer to that is no. And if the answer to that is today no, then what is it that we are really debating? The question is, what is it that is maximizing the value today? And the answer to that, my respectful submission is obvious. Then you also have a situation where you are merely saying, oh, it happened very well in Singapore or in London, therefore it must probably happen very well here. UK does not have a written constitution. It happened very well there. Are we saying that we have to burn up our book? Absolutely not. Why are we so fixated with copying what goes on in London or in Singapore? Why aren't we talking about what needs to be done to evolve something that works for India and for the millions and millions here to resolve those problems? Not a whisper about that from the persons who are speaking for the proposition. And I think I have one last thing to say, which is that from what Mr. Joshi began by saying to when he came to his rebuttal, he had softened his stance and changed his mind. I think that is as good an endorsement of what we've said as I was hoping for. Thank you for your patience. Thank you.
Thank you all debaters for this spectacular and insightful debate that we have just had. The proposition has told you that India needs reliability, enforceability, credibility, and global stature that institutional arbitration offers the structure to get us here. The opposition has now countered with force, arguing that flexibility, cost efficiency, and party autonomy, the hallmarks of ad hoc arbitration, are not weaknesses but strengths tailored to India's commercial reality. You have now heard the full battle of ideas, and while the speeches may have ended, the debate does not, because the final word belongs to you. Now, members of the House, to decide whether the motion shall stand or not, I now put it to you. Those in favor of the motion, can I see a show of hands? Okay. And those against the motion? Quite a lot more hands than when it started. Seems to have been quite a swing thanks to the masala dosa debate that also came through. Thank you, members. The House has spoken. On behalf of the host committee, thank you to our speakers, thank you to this energetic Bangalore audience, and may your next arbitration be cheaper, quicker, and involve fewer WhatsApp groups.
Thank you to our avid debaters. We sat you close enough, hoping for some physical blows, but we note you did not pull the punches on everything that you had to say. Thank you so much for joining us here today. I request Mr. Harish Narsappa to kindly felicitate our debaters. May I request you to take your seats in the audience, please?
ADR week is
Good afternoon and a very warm welcome to Honorable Mr. Justice R.V. Ravindran, Honorable Mrs. Justice K.S. Mudgal, Honorable Board of Governors of the Arbitration Centre, Bengaluru, Honorable Judges of the High Court of Karnataka, retired Honorable Judges, High Court of Karnataka, Registrars of the High Court of Karnataka, Unit Heads of the District Judiciary, State of Karnataka, Learned District Judges of the District and Civil Judiciary, State of Karnataka, Director and Deputy Directors of the Karnataka Arbitration Centre, Director of the Karnataka Judicial Academy, learned senior advocates of the Karnataka Bar, members of the Advocates Association Bengaluru, my fellow advocates at the bar, and esteemed guests. On behalf of the Patrons-in-Chief of the Bengaluru ADR Week Trust, Mr. Harish Narsappa, Mr. Srirangan Subbanna, Mr. Arun Kumar, and the members of the organizing committee, Mr. Pradeep Nayak, Ms. Manisha Kongovi, Ms. Pinaz Mehta, Ms. Lakshmi Menon, Mr. Prashant VG, Mr. Mrinal Shankar, and myself, it is my honor and privilege to welcome you to the closing ceremony of the second edition of the Bengaluru ADR Week. We now have a short video clip of the events of the weekend that was.
And while we do have complete faith in our judiciary, it is a fact that our judiciary is overburdened.
ADR Week is an initiative to increase the consciousness and awareness around alternative dispute resolution and to bring a culture, and we kind of unleash the potential of ADR in Karnataka.
We are here coming together as a community of lawyers, judges, arbitrators, arbitration council to create a community, and with that community to strengthen each other's faith in the ecosystem and create institutions that help bring about change in the system.
Typically, people have been used to going to courts, and we've heard enough and more of the court systems and Tariq Lidarik and all of those things. So what we really are looking at is a cutaway of that process. Arbitrations are essentially private courtrooms, right? And you choose the process, you choose your arbitrator, you choose your counsel of course, and you choose how the whole process goes on. And that's the beauty of arbitration.
The implication of using private modes of dispute resolution is unburdening the courts, faster delivery of justice, better access to justice for people who don't need their rights to be adjudicated in a court.
What I think is unique about this ADR week is that there's a proper synchrony between the practicing bar and also the bench, the judges of the district judiciary, the judges in the commercial courts, judges in the high courts, judges from Supreme Court, retired, past and present, are all involved. I think that's what makes this unique.
This is my first time at the ADR week. I've always heard of it in the past and I've always wanted to be a part of it, and I'm actually glad that this year I could be a participant. The sessions are quite enriching and insightful, and it's honestly nice to see so many esteemed panelists speaking about their views and how ADR is shaping the current litigation sphere and what are the potential challenges and how we can overcome it. So it's been great so far.
Initiatives like the ADR Week are really beneficial for students and even professionals to learn more.
As somebody who's just stepping into this field, they have given me a lot of things to learn, and I am very happy that I've got a first-hand experience out of this, and I am looking forward to learn many more things.
There are multiple ways in which the High Court has changed and will continue to change the way we do ADR. The Arbitration Center itself has been set up by the High Court, so the rules are set up by the High Court. The way it functions is governed by the High Court. And the High Court also oversees the manner in which these arbitrations are held and their awards are challenged subsequently.
That is a strength for sure. And where the institution and the arbitral institution, the court system and the arbitral institution can work hand in hand, it's for us to exploit the benefits.
Today, we know that there are many disputes which are not traditional disputes anymore. And your typical traditional disputes are still confined to your regular civil courts. But now we've traveled far beyond all of those. And therefore, it becomes all the more important that we have a larger pool of younger lawyers or more experienced lawyers even.
Sound first principles, a sound ethical framework, coupled with the right kind of technical skills, is perhaps what most young arbitrators and arbitration professionals must look at building. I do believe that with the quality of talent and professionals we have in Bangalore, it certainly has the wherewithals to be on par with the best and the brightest in the world.
Bangalore has so many fantastic practitioners who have ideas which can be used by the arbitration center, which can be used by the Judicial Academy, and which we hope that in future will be used to make better rules to make ADR more efficient in Bangalore and in India as well.
I request Honorable Mr. Justice R.V. Ravindran, Honorable Mrs. Justice K.S. Mudgal, Honorable Justice Sachin S. Magadum, Honorable Justice R. Natraj, Honorable Justice E.S. Indiresh to take their seats on the stage. Please rise for the Nada Gite. Please be seated. I now request Mr. Dinesh Hegde, Director, Arbitration and Conciliation Center, Bengaluru, to deliver the welcome address.
Very good afternoon, one and all. Respected dignitaries on the dais, Honorable Sri Justice R.V. Ravindran, former Judge of the Supreme Court of India, Honorable Srimati Justice K.S. Mudagal, Judge High Court of Karnataka and President of the Karnataka Judicial Academy, Honorable Sri Justice Sachin S. Magadam, Honorable Justice R. Nataraj, Honorable Sri Justice E.S. Indiresh, Board of Governors of the Arbitration Center, distinguished guests, esteemed members of the bar, members of the ADRB committee, students, delegates, ladies and gentlemen. A very warm and respectful welcome to each one of you to the closing ceremony of the Bengaluru Alternative Disputes Resolution Week 2025. Over the past 3 days, we have witnessed an inspiring confluence of thought, experience, and innovation. ADR Week has grown into a platform that not only reflects Bangaluru's leadership in arbitration, conciliation, and mediation, but also reinforces our collective commitment to the strengthening India's dispute resolution ecosystem. This year's theme, augmenting the arbitration ecospace, building confidence in ADR systems, has been brought to life through insightful sessions, informed deliberations, and the rich participation of experts from diverse fields. Your contributions have added immense value to the continuing journey of positioning Bengaluru as a preferred destination for efficient, credible, and world-class dispute resolution. It is our privilege and honor to have with us today Honorable Sri Justice R.V. Ravindran, whose rich experience and guidance continue to shape the landscape of arbitration in India. We are eagerly waiting to listen to His Lordship's keynote address today. I, on behalf of this entire team of organizers and on my own behalf, extend a hearty welcome to His Lordship. I extend a heartfelt welcome to Honorable Srimati Justice K.S. Mudagal, who is presiding over this ceremony. It is her leadership vision which has taken us so far in this ADR Week mission. Welcome your leadership. Honorable President and Board of Governors of the Center have been our pillar of support. In absentia, I remember the true leadership initiative of Honorable President Justice D.K. Singh and thank His Lordship. I acknowledge the gracious presence of the Board of Governors, Honorable Sri Justice Sachin S. Magadam, Honorable Sri Justice R. Nataraj, Honorable Sri Justice E.S. Indiresh, in absentia, Honorable Justice M.G. Uma, and together I extend them a respectful welcome. Your leadership and unwavering support remain the strongest pillars of Arbitration Center. On behalf of the organizers, I extend warm and affectionate welcome to all the honorable judges of the High Court of Karnataka who are with us today, this afternoon. I heartily welcome Sri K.S. Bharat Kumar, Honorable Registrar General, and all the registrars of the Honorable High Court of Karnataka to this ceremony, who have always stood with us. I also welcome Srimati N.V. Bhavani, Principal Law Secretary to Government of Karnataka. I also take this moment to acknowledge the efforts of Srimati H.R. Radha, Director, and her team of officers, Karnataka Judicial Academy. The Advocates Association, our Arbitration Center's team, resource persons, and volunteers for their dedication in making this year's ADR Week a meaningful success. I extend an affectionate welcome to all to this closing ceremony. I, on behalf of the organizers, welcome the honorable chairpersons, panelists, delegates, participants, advocates, and students to this closing ceremony. Thank you for your enthusiasm and engagement. Your presence enriches this initiative and motivates for us to work hard each year. Press and media personnels are also with us, and I welcome them to this closing ceremony. On behalf of the Arbitration and Conciliation Center, Bengaluru, I once again extend a warm welcome to each one of you who have directly or indirectly contributed for the success of this event. We look forward to your continued guidance and participation as we collectively build a stronger ADR culture for the future. Thank you.
Thank you, Mr. Hegde. Gratitude would not begin to define our sentiment towards Justice Ravindran, who has not only lent his support and advice to ensuring the success of Bengaluru ADR Week, but has given his time freely and never turned down a request to speak and deliberate on pressing issues. I request Honorable Mr. Justice Magdum and Senior Advocate Mr. Arun Kumar to present Justice Ravindran with a token of our appreciation. For all the support extended to us and for being our pillar of strength from the very first mention of Bengaluru ADR Week to seeing it through 2 successful editions, we would like to present Justice Mudgal with a token of our appreciation. I call upon Mrs. H.R. Radha, Director, Karnataka Judicial Academy, and Mr. Prashant VG to present Justice Mudgal with a token of our gratitude. We are grateful to the Board of Governors of the Arbitration and Conciliation Center, Bengaluru, for their support and dedication towards making Bengaluru ADR Week a grand success. I request Mr. Harish Narsappa to present a token of our appreciation to Justice Magadum. To Justice Natraj. And to Justice Indresh. We are grateful to Honorable Mr. Justice Krishna Kumar for his constant support of Bengaluru ADR Week and for being here with us today. I request Ms. Manisha Kongovi to present Justice Kumar with a token of our gratitude. The last 3 days have proved the commitment of the bar and bench to work together not only to discuss and deliberate on the steps to be taken to ensure that arbitration and mediation are effectively used across Karnataka, but also to formulate strategies to implement the suggestions and action real change. I request Mr. Sriranga Subanna to deliver the report of the event.
Good afternoon to all the dignitaries on and off the dais. I'm the Chitragupta for the event. This second ADR week has had 6 panel discussions involving 36 speakers who have placed their candid views about various aspects which have been discussed. There was a unique interactive session of arbitrators which has provided a platform for arbitrators to place their views and discuss various aspects. And a lot of things have come out of that process. There are a lot of suggestions which have come about the manner in which the center is functioning, amendments possibly which are necessary to the rules, the way the fee structure, etc. All of them are taken note of, and it will form a part of the report to be submitted by us, a detailed report. It is also felt that such interactions amongst arbitrators, which has not taken place, is something which is needed on a regular basis. And the idea is to, with in association with KJA and the center, we are planning to have such sessions to take place on regular intervals. So that was a very unique experience that we have had, and it has been very fruitful. We had a training session for young advocates. More than 100 young advocates participated in that process, and they have all, the feedback is that they were greatly benefited by the training program that was conducted. And we had a session on real estate and arbitration. It has been highlighted that there is a large vacuum with regard to existing laws pertaining to construction, real estate related issues. And the need for having curriculum in educational institutions, especially as certification courses, is the necessity. Some institutions have it, most of the institutions don't have it. So we intend to communicate to the Bar Council, highlighting this aspect, and also possibly write to the Law Commission about the lacuna that has been pointed out. In other debates, various aspects of working of provisions of Arbitration Act have been discussed. One aspect which has been highlighted is the manner in which the jurisdiction under Section 29A of Arbitration Act with regard to extension of time is being dealt with. And there are various suggestions with regard to that which have been taken note of, which will form part of the report. With regard to mediation and the pre-institutional mediation, various drawbacks of the pre-institutional mediation, and also as to whether it is serving its purpose, there has been a lot of debate about it. Further, Justice Banerjee was candid in placing before this forum the problems that are being faced by the mediation center and the process of mediation, especially lack of infrastructure available for mediation in places other than the capital city. And those are aspects possibly which have to be highlighted by us, and in the report we will be highlighting those aspects. One more very important aspect which has been highlighted is the requirement of use of technology in various aspects of the process of dispute resolution. And there has been specific reference to particular use of technology in the institutions like Arbitration Center. So we have gathered information, and also we would like to expand that and provide the Bangalore Arbitration Center, which is going to acquire additional space, to use technology efficiently so that we can make the center a better place to arbitrate. Then last aspect is with regard to state withdrawing from the process of arbitration, both center and state. Justice Shurath Govindraj was placing data with regard to the number of proceedings that have been instituted, close to 11 crores of cases filed between a particular period, and how many cases have been decided by courts, etc. So major part of this litigation would be state, and state withdrawing from arbitration process will have its effect on the clogging of the system. And these are aspects which possibly will have to be taken note of, and we will be providing our feedback based on the elaborate discussions that were held today in the deliberations. And overall, the energy in ADR week from day one till the ending of the session has remained very high, which is also very unique. We see that as the conference progresses, the energy drops. But however, we saw in the last debate as well, it was fully power-packed and full of energy. And therefore, in my conclusion, ADR week has been a grand success. And as Mudgal Madam had said, in the last first ADR week, the Damaru of ADR week has been resonating quite well. Thank you.
Thank you, sir, for the succinct summary of the whirlwind of sessions and discussions that have taken place over the last 2 days. I now request Honorable Mrs. Justice K.S. Mudgal to deliver the special address.
Respected dignitaries on the dais, Honorable Shri Justice R.V. Ravindran, former Judge of the Supreme Court of India, my esteemed brothers, Justice Sachin S. Magdum, Justice R. Natraj, Justice E.S. Indiresh, the Board of Governors of Arbitration Center, my esteemed brother, Justice Krishna Kumar, Judge High Court of Karnataka and member of the Board of Governors, Karnataka Judicial Academy, respected former judges of High Court of Karnataka and District Judiciary who are amongst the audience today, judicial officers, distinguished guests, learned members of the bar, members of ADR Week Committee, students, delegates, press and media, ladies and gentlemen, Ellargu Namaskara, my pranams to all too. It's my proud privilege to share the dais with the Honorable Justice Ravindran in this closing ceremony of Bangalore Alternative Disputes Resolution Week 2025. His Lordship was present even during the pre-inaugural session, and I am informed that there was fruitful interaction amongst the seasoned arbitrators of the center. The vision of His Lordship will be cherished as a compass to reach the greater milestone in the path of arbitration. I also have to crack a secret here. His Lordship was my first administrative judge in Mysore, and next month I am retiring, so I am closing this program with His Lordship. The organizing committee member has narrated the report of Bangalore ADR Week 2025, and it's very elaborative and exhaustive. I congratulate the organizers for handpicking the topics for panel discussions. I'm confident that the insightful discussions on the topics will lead to systematic improvement of the arbitration world. Bangalore is often referred to as the IT hub or Valley of India. It's a city known for its diversity and inclusiveness, an excellent blend of cultural variety and cutting-edge technologies. As per Savills Growth Hubs Index, with projected GDP of 8.5%, Bangalore will be the world's fastest growing city for the next 15 years. With economic growth, the consequential commercial litigation is bound to skyrocket. Further, in a technology-driven digital age, the disputes covering topics like data privacy and intellectual property, etc., are also bound to increase. Arbitration, which is known for its efficacy, flexibility, speed, and confidentiality, will be an effective tool to regulate commercial and technologically driven litigations. On the question of what makes an effective arbitration framework, I believe there are several key features which are essentially, namely, a strong legal system which steadfastly upholds the rule of law, a sufficient pool of competent arbitrators and a dedicated bar, most importantly, a strong arbitral institution with modern hearing facilities. Arbitration and Conciliation Center, Bangalore, is a preferred arbitral institution for adjudication of both domestic and international arbitration due to its cost effectiveness and panel of highly skilled arbitrators who carry an enriched judicial legacy behind them. As the erstwhile president of Arbitration and Conciliation Center, Bangalore, I have personally witnessed the surge in the arbitration cases in the center. Yesterday it was mentioned that statistics disclose that when center was established in 2013, there were only 28 cases. Whereas as per the statistics made known to me, as on 31/10/2025, the pendency is 1,411. There is too much pressure on the physical infrastructure, and I am happy to note that steps are being taken by the government for expansion of the center. There is an onerous responsibility on each of the stakeholders present here today to strive hard to make Bangalore a preferred arbitration destination to resolve the commercial disputes through the process of arbitration. ADR Week has grown into a platform that not only brings together all stakeholders but also tries to achieve Bangalore as a preferred destination of arbitration. I would like to conclude with the quote of Mankutimma. This time Damaru is not there, I am going to Mankutimma. ಪುಸ್ತಕದಿ ದೊರೆತ ಅರಿವು ಮಸ್ತಕದಿ ತಳೆದ ಮನಿ, ಪುಸ್ತಕದಿ ದೊರೆತ ಅರಿವು ಮಸ್ತಕದ ತಳೆದ ಮನಿ, ಚಿತ್ತದೊಳು ಬೆಳೆದರಿವು ತರುತಳೆದ ಪುಷ್ಪ, ವಸ್ತು ಸಾಕ್ಷಾತ್ಕಾರ ವಂತರೀಕ್ಷಣೆಯಿಂದ, ವಸ್ತು ಸಾಕ್ಷಾತ್ಕಾರ ವಂತರೀಕ್ಷಣೆಯಿಂದ ಶಾಸ್ತ್ರಿತನದಿಂದಲ್ಲ ಮಂಕುತಿಮ್ಮ. Means knowledge gained by reading books is like an ornament on the top of the head. It's only external. Knowledge that blooms from contemplation is like a flower on a creeper. The realization of truth can only be attained by contemplation or introspection, not just by being called well-read. That's what Mankutimma says. Since it is a closing ceremony, we need to introspect and delve deep into the deliberations that took place to enhance our wisdom, ultimately to serve the justice seekers. If such introspection leads us to the theme of event, augmenting the arbitration ecospace, building confidence in ADR systems, the object and purpose of organizing this mega event stands fulfilled. I thank you all for giving me this opportunity to participate in this program and holding it here. Thank you all once again. Jai Hind, Jai Karnataka.
Thank you, Justice Mulkal, for your insightful thoughts and for the positive note on which you send us forth towards arbitration. I request Honorable Mr. Justice R.V. Ravindran to deliver the keynote address.
Justice Mudgal, President, Karnataka Judicial Academy, Justice Magdam, Justice Natraj, Justice Indresh, the members of the Board of Governors of the Arbitration and Conciliation Center, Justice Krishna Kumar, I see Justice Anand Bhaira Reddy, other judges of the district judiciary, members of the registry, Mr. Dinesh Hegde, Director of the Arbitration and Conciliation Center, Srimati Radha, Director of Karnataka Judicial Academy, Mr. Harish Narsappa, Mr. Sriranga, and Mr. Arun Kumar of Bangalore ADR Week Trust, members of the bar, the arbitrators, learned arbitrators, ladies, gentlemen, and students. Let me, at the outset, congratulate the Arbitration and Conciliation Center, the Karnataka Judicial Academy, the Advocates Association Bangalore, and the Bangalore ADR Week Trust for successfully conducting a very useful Bangalore ADR Week, where various ways of augmenting the arbitration eco space by building confidence in the ADR system were discussed and analyzed. I also heard today some encomiums being paid, good things being said about the arbitrators, about the members of the bar, and the Bangalore Arbitration and Conciliation Center. Every such statement requires a counter statement by someone who can be the disruptor. I say, when I say or when I am going to say something, I am told the press is also here. I do not know the press is here or not. I do not want somebody saying that Justice Ravindran said all these are wrong. Anta. So we will work in a assumed capacity. If something is wrong, if something requires to be set right, what I may say can be used. If everything is all right, this can be ignored, because I have not personally seen what is happening, and whatever I say depends on hearsay. Therefore, nobody should take offense or curse me. But because of my age and because of my situation, I feel that if certain things have to be said, it has to be pointed out. Please take it in that sense. The common thread that emerged from the discussion is the need for commitment and discipline on the part of all stakeholders to make Bangalore a reliable arbitration hub by creating a more favorable arbitration ecosystem. Earlier, in fact, in my time, when we spoke about arbitration, the concern about the business industry going abroad, going to Singapore, going to London, going to Hong Kong, and not doing enough arbitrations in India. That was our concern, and we were trying to get back arbitration to India. Ivaga, there is a additional layer. Now, the added concern in some states like Karnataka is about arbitrations from their state moving to Delhi and Mumbai due to a perception that Delhi and Mumbai have better arbitration ecosystems. I have learned during discussions with some investors, industrialists, and business houses that they are considering Delhi and Mumbai as the seat of arbitration for application of curial law in regard to contracts which are to be executed and performed in Karnataka. The perceived reasons for such preference of Mumbai and Delhi is, one is the delays on account of jurisdiction under the Arbitration and Conciliation Act being exercised by courts lower than the High Court in Bangalore. That is given as one of the reasons because it adds one more tire in the litigation. Second, that was mentioned to me was the high stamp duty that is payable on awards if they are delivered in Karnataka. This is also something that was mentioned. The third is the lack of adequate state-of-the-art facilities and infrastructure for conducting arbitrations. The fourth is, pardon me for saying, the absence of a committed arbitration bar. That is very much an issue. The ease with which disputants can approach court and get reliefs under the Arbitration and Conciliation Act, the reasonableness of the stamp duty payable on awards, the availability of state-of-the-art facilities for conducting arbitrations, and the existence of a committed arbitration bar all play an important role in building up the required arbitration ecosystem. Now let us consider, as I said, let us assume if something is lacking, what can be done. I also agree that everything is there. Yeah. It is therefore the duty of all stakeholders to make Bangalore an attractive destination for alternative dispute resolution, especially arbitration. The question then is, who are the stakeholders? The identified stakeholders are, 1, the arbitrators themselves, number 2, members of the bar, number 3, arbitral institutions. At present in Karnataka, in Bangalore, when you say arbitral institutions, it should be rather institution because there is only the Arbitration and Conciliation Center, Bangalore, and nothing else. I do not know whether something else is there, but to my knowledge, it is the only thing. The fourth is the High Court, because High Court controls the arbitration center. And last, the state government, because state government controls the law that affects stamp duty and jurisdiction and other things. Making Bangalore an arbitration hub and augmenting the arbitration ecospace requires commitment, discipline, and sacrifices on the part of arbitrators and members of the bar, as also initiation of necessary steps by the High Court and the state government and the arbitral institutions. The arbitrators, I'm coming to a little sensitive issues. Most of the arbitrators in India and also in Bangalore are retired judges, which is not so in most of the other jurisdictions. In all other countries, it is the advocates, senior advocates, senior advocates does not mean designated senior advocates, advocates who had a lot of experience and who cease to be in active practice in courts. They are the arbitrators or technocrats and also judges. But here we have majority of judges and majority of retired judges. Two things happen with retired judges. One, a feeling that they worked for their entire life and therefore they can take it easy. I'm sorry, I'm also one of them, therefore please don't mistake me for saying this. The second is being wedded to CPC and Evidence Act and forgetting that Arbitration Act specifically says you are not governed by CPC, you are not governed by the Evidence Act, only the fundamental principles underlying these two are applicable. This is the real problem. And what is the problem with advocates? They think our arbitration center is like court. They come and seek adjournment, same reasons. Grandfather is dead, so-and-so is unwell, traffic, Bangalore traffic, anything goes. Arbitrator comes, the other side comes, and routinely requests are made. So we have a situation where the arbitrators are following the strict rules of Code of Civil Procedure and the Evidence Act when it is not necessary. And the lawyers are taking it easy and treating arbitrations as if they are in court, forgetting that for courts there is no Section 29A. The 1 year limitation is ignored. Section 19 is ignored, where it says you can have your own procedure instead of following CPC and Evidence Act. All this is happening. Section 24 is ignored, which simplifies and expedites hearings. All these are ignored, and we have an ecosystem in Bangalore, in the arbitration center. I do not want to name the center or the arbitrators or the advocates, but by some combination, they have become alternative courts. Andre, the delays that are associated with courts, the technicalities that are associated with courts continue to plague the arbitrations in Bangalore. Therefore, that's why I said, if it is happening. If it is not happening, I am not saying. ಯಾರೋ ಹೇಳಿದ್ರು ಅದನ್ನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಇದರಿಂದ ಇರಬಹುದು ಅಂತ. So there should be a commitment, an effort, a conscious effort by the lawyers and by the arbitrators to shift gear and move from court litigation to arbitration. Time ಕೇಳಬಾರ್ದು, ಟೈಮ್ ಕೇಳಿದ್ರೆ ಇವ್ರು ಕೊಡಬಾರ್ದು. These are the two fundamental principles. ಏನಂತಾರೆ, we will get a bad name. Yes, you will get a bad name. But luckily you are being appointed, most of you are appointed by the High Court. Whether you have a bad name with the lawyers or not does not matter. Be strict. And if the arbitrators are strict, ultimately they will get a good name. In the short term, they may not get, they may not be popular. But once, it is like a court. I was telling yesterday, in High Court or trial court, if the lawyers know that a judge is strict, everybody will attend his court. Court hall will be full. And if you are very good, accommodating lawyers, his court will always be empty. You will be searching for cases. Arbitration is meant to be a quicker remedy, a speedier remedy. And the legislation has made the time, as said, 12 months. And how many cases it is being disposed of in 12 months? I am an arbitrator, I know. I am also asking for extension of time. Maybe I should also change. Whenever I say something which may be treated as an advice, it is also for me. Because some people may think, who is he to give advice? He is also an arbitrator. Somebody should do it, and I am trying to do it. Therefore, let there be an attitudinal change in the lawyers. Whoever who takes up an arbitration should proceed with the arbitration. I was told that there are 130 matters of 2022 and 280 matters of 2023 pending in the arbitration center, when the period that is prescribed is 1 year, that is 12 months after completion of the pleadings. So something requires to be done. And the first thing is the lawyers and arbitration. If they change, things will improve. The second is about the institution itself. Institutional arbitration is preferred to ad hoc arbitrations. ಎರಡೂ ಒಳ್ಳೆಯದೇ. ಸರಿಯಾಗಿ ಮಾಡಿದ್ರೆ ad hoc ಆರ್ಬಿಟ್ರೇಷನ್ನು ಸರಿ ಇದೆ, ಇನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಆರ್ಬಿಟ್ರೇಷನ್ನು ಸರಿ ಇದೆ. ಸರಿಯಾಗಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೇನು, ಇದೂ ಸರಿ ಇಲ್ಲ, ಅದೂ ಸರಿ ಇಲ್ಲ. Institutional arbitration is preferred to ad hoc arbitrations to avoid delays, high cost, and to introduce professionalism in the conduct of arbitrations. When the Act requires the arbitrators to be completed in 12 months after pleadings, having around 130 matters of the year 2022 and 280 matters of 2023 in the Arbitration and Conciliation Center is a matter of concern, particularly having regard to the fact that many of the arbitrations are related to MSME Act and arbitrations involving amounts less than 10 crores. The center can improve the arbitration ecosystem by certain improvisations. Let me refer to a few of the areas where center can take proactive steps. For example, once the 12-month period expires and the arbitration proceedings moves into the extension period, the center can start monitoring and fixing of hearings and adjournments to quicken the process of completion. I am told now, when a matter is assigned to an arbitrator, of course, as it ought to be, the arbitrator is in control, because it is like a quasi-judicial proceedings. The center cannot interfere in the functions of the arbitrator. But the institution can certainly supervise. If it exceeds 12 months, ask why are you giving adjournments, why it is not being completed. Please ensure the matter is completed within 6 months. Something can be said. That part of it is not at present being done because of the respect, not because of want of any commitment on the part of the center, because of the respect they have to the High Court judges and the members of the district judiciary who are the arbitrators. Let not that respect be misused. Therefore, if there is the time is over, 12 months time is over, let the center very politely monitor what adjournments are given, how long time is being taken for either for proceeding with the evidence or making the award. By the very fact that the institution is watching is sufficient to make the arbitrators, to make the lawyers to cooperate, to give better results. It can take a long term, it can also take long-term and short-term steps to expedite the hearings. For example, one frequent complaint is the non-availability of the halls for arbitrations leading to longer adjournments. Ad hoc arbitrations nalli ಒಂದು ಪ್ರಾಬ್ಲಮ್ ಅಂದರೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ಯಾವುದು ದಟ್ ಹಾಲ್ ಇಲ್ಲ ಅಂತ ಅದಕ್ಕೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡಬೇಕು 1 ತಿಂಗಳು 2 ತಿಂಗಳು 3 ತಿಂಗಳು ಅಂದರೆ ಇಟ್ ಈಸ್ ಮೀನಿಂಗ್ಲೆಸ್. ವಾಟ್ ಈಸ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ಹ್ಯಾವಿಂಗ್ ಎ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ to quicken the process of arbitration and then say that hall is not available and therefore you take have a longer date. So a 1 month date or a 15 days date becomes a 2 months date or 3 months date. Then where do we stand? How can there be disposal within 12 months? The entire purpose of the Arbitration Act is defeated if it is not able to proceed in a very smooth and quick manner. Many arbitrators and counsels state that if shorter dates or block dates can be made feasible, the arbitration process could be quickened. One positive step is proposal to increase the available area from 10,000 square feet to 22,000 square feet, and I'm sure that will ease a lot of difficulties. Having regard to the non-availability of the halls and the absence of a arbitration bar. Arbitration bar andre ಏನು? The simple definition of a arbitration bar ಅಂದರೆ arbitration ಇದ್ದರೆ ಬಂದು arbitration ನಡೆಸಬೇಕು. ನನಗೆ ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಕೇಸ್ ಇದೆ, ಟ್ರೈಬ್ಯುನಲ್ನಲ್ಲಿ ಕೇಸ್ ಇದೆ, ನನ್ನ ಕ್ಲೈಂಟ್ನ ಮೀಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ದೇ ಆರ್ ನಾಟ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಬಾರ್. They are other bar, of course I am not really referring to some other bar, the regular bar who consider arbitration as a side business. No sir, it is not. Arbitration will never succeed if it is secondary to your main work. Arbitration, if you are in the arbitration bar, if you have an arbitration, you give preference to arbitration. Adu beku. But it has got its own difficulties. For the arbitration bar to develop, there should be sufficient number of arbitration cases. One difficulty faced by the lawyers is if they purely depend on arbitrations, they may have to close their office or tighten their belts. Therefore, by force, they are forced to do other work. And if they are forced to do other work, they have cases in the High Court. Obviously, you can't tell the High Court that I have an arbitration case, though recently the Attorney General told the Supreme Court, I have an arbitration, therefore please give me an adjournment, which was never heard in our days. But so, therefore, the bar really has a problem. If there should be an arbitration bar, there should be sufficient work. If there should be sufficient work, there should be good enough arbitrations, good enough arbitrators, good enough arbitration lawyers, and good enough ecosystem. ಅದು ಡೆವಲಪ್ ಆಗೋವರೆಗೂ ಸಮ್ ಇಂಟ್ರಿಮ್ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಬೇಕು. ಅಟ್ ದಿ ಸೇಮ್ ಟೈಮ್ ಡಿಲೇ ಆಗಬಾರ್ದು. ಏನು ಮಾಡಬೇಕು? ದಿ ಡೆಲ್ಲಿ ಸಿಸ್ಟಮ್ ಈಸ್ ದಿ ಬೆಸ್ಟ್ ಸಿಸ್ಟಮ್. ಅಂದರೆ ಹ್ಯಾವ್ ಈವ್ನಿಂಗ್ ಹಿಯರಿಂಗ್ಸ್ ಆಲ್ಸೋ. Why not the arbitration center work? Why should it work only from 10 a.m. to 5:30 p.m.? Why not to have a evening session? So the minute a lawyer asks for time saying, I have work in court, all right, well, let us take it at 5 o'clock. So the matter is not urgent, does not go. And similarly, not only I am giving the example of evenings, what about Saturdays? What about Sundays? What about government holidays? I was telling Justice Nataraj that you see one or two of the arbitrators who appeared to me before me in Bangalore arbitration, they always prefer Sundays. I say yes, they say yes, everybody is happy. But if you have a real arbitration bar, that may not be necessary. But until the real arbitration bar in Bangalore takes off, let us have evening arbitrations, let us have Sunday arbitrations, and the center should provide for it. One difficulty is center is run by the High Court, and therefore it is the High Court employees and the honorable judges who are manning it, and they are entitled to say that we will not work on Sundays, we will not work at 5 o'clock, after 5 o'clock, and you can't make them work. Therefore, there is a deadlock. But all that I say is, if you have a will, there is a way. If for having a evening session, or having a Sunday session, you don't require the government, the High Court officials at all. You can have some contract employees or some system, find a system, or by paying overtime, some cleric, one peon to open the hall and close it after 7:30, or one clerk to manage it is sufficient. It is the stenographer and clerk who are necessary. Therefore, there should be an effort, some effort to see the services given by the center are improved, and nobody can point a finger at the center and say, you are not having sufficient halls, you have 1,000 cases, you have only 9 halls, we are not in a position to proceed with the matter. That complaint should not be there. The Board of Governors are here, they should make some effort to ensure that the hall is available in the evenings and Sundays, and I am sure the lawyers also will find it because that will not interfere with the work. All this is an interim arrangement till a regular arbitration bar develops as it has happened in Mumbai. Then, the third is, this is also again the about the center, I do not know, it's already happening. There are 3 types of cases in the center. One is cases referred under section 11 of the Act. Number 2, cases which happen when the contracts have a provision saying that the center's rules will apply, and under the center the arbitration will take place, and therefore reference is made by the parties directly to the center. Third is under the MSME Act. The requirements of 3 types are different. If they are properly bifurcated, and for the MSME cases, some shorter way of dealing with it can be employed, I think there will be, the lesser number of cases will be there, and more number of cases can be disposed of. These are the, another thing I can mention is, I do not know, this also may already be happening, is for non-trial matters, there are a lot of preliminary hearings. It can be done purely online. Nobody need appear in the center. Center may organize the Zoom meeting, and all the meetings can take place there. If that is done, the requirement of hall for certain preliminary purposes can be avoided, and halls will be available exclusively for the trial hearings. This is one thing. The other area is there has been a complaint. This is also a very touchy subject about the awards being not of a quality which is expected from the retired judges. It gives room for two things, because if the awards are not good, the arbitration as such loses credibility. That is one. Number two, there are more chances of the awards being challenged before court. Therefore, if there is some way of scrutinizing the awards by the institution before they are pronounced, and which is not something new, it is happening in all other jurisdictions. And I was again telling somebody in Singapore, when I did the first arbitration as a retired Supreme Court judge with a lot of these things, saying I am a retired Supreme Court judge. Some girl there sitting from just out of college pointed out 40 typographical errors in the award. So my balloon was totally gone. No, it is absolutely necessary, because maybe because of age, maybe because you don't have the secretarial assistance, maybe there are errors. There is nothing wrong if the errors are pointed out by some youngster who is working in the center. Not only the typographical errors or clerical errors, maybe a decision which has been overruled might have been cited, or something which is a dispute is formulated or an issue is formulated by oversight the arbitrator has not considered. It can be pointed out. The job of the institution is not to supervise or change or alter the award. It is merely to point out things which can be improved upon. If that is done, the quality of awards will go up. And if the regular supervision is there, the quality of hearings will go up. Time will be reduced. Delay will be cut. Automatically, arbitration will improve. The ecosystem will be created. Now, ecosystem beku, ಚೆನ್ನಾಗಿರಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯಾವುದು ಮಾಡಿಲ್ಲ ಅಂದರೆ nothing can happen. Things will remain as it is. One other idea which I want to propose is for the Bangalore Arbitration and Conciliation Center and Bangalore Mediation Center to collaborate with each other to popularize and implement MedArb, where the matter is first referred to mediation, and if there is no settlement through mediation, the dispute is automatically transferred to the arbitration center for decision. Now, I have a feeling that mediation also will contribute a lot for quickening and reducing arbitrations. In fact, there is a provision in the Arbitration Act casting a duty on the arbitral tribunals to encourage mediation. Therefore, if they can work, both are under the control of the High Court, if they can work hand in hand and encourage MedArb, that will help the litigant public a lot. As the central is controlled and run by the High Court, and the curial law is controlled by the state government, they can also take meaningful steps to build up the arbitral ecosystem to deliver better services relating to arbitration, which increases the credibility of arbitrations in the state. Let me hasten to add that my intent is not to find fault with the working styles of the arbitrators and the members of the bar, nor is it my intent to find fault with the working of the center. My limited object is to evoke a discussion and debate among the stakeholders to improve the arbitration ecospace to serve the public more efficiently and effectively. Everyone agrees that there should be more professionalism among arbitrators, and Bangalore requires a committed arbitration bar which gives preference to arbitration. Let us all do it. My apologies to all concerned if I have overstepped my limits in making some suggestions. Thank you.
Thank you, Justice Ravindran, for the honest assessment of the prevailing situation in the arbitration space and the suggested steps which all the stakeholders are required to take in order to improve the ecospace and truly make arbitration a preferred method for dispute resolution in Bengaluru. We go forward with a mandate for what each of us can do to make arbitration better and more effective. As we come to the close of the second edition of Bengaluru ADR Week, we would be remiss if we did not acknowledge the contribution of all those who have worked tirelessly to make this event a success. I request Mr. Pradeep Nayak to deliver the vote of thanks.
This has been a weekend of learning, exchanging ideas, and taking a few more steps towards augmenting the arbitration ecosystem in Bangalore. On behalf of the ADR Week Organizing Committee, we really have so much to be grateful for. We are privileged to have had the support of Justice Vibhu Bakru, the Honorable Chief Justice of High Court of Karnataka, who set the tone for the program and discussions and who reinforced the judiciary's commitment to developing a principled, efficient, and trustworthy ADR ecosystem. We're equally grateful to Srimati Justice K.S. Mudgal, Judge of the Honorable High Court of Karnataka and President of the Karnataka Judicial Academy. Absolutely none of this would have been possible without Justice Mudgal. She personally turbocharged the germ of an idea that we had a year ago and propelled us to where we are today. Ma'am, your leadership, mentorship, guidance to the committee is invaluable and we are very grateful for it. Our sincere thanks to Honorable Justice D.K. Singh, Judge of the High Court of Karnataka and President of the Arbitration Center. We thank the Honorable Members of the Board of Governors of the Karnataka Judicial Academy, Justice Sunil Dutt Yadav, Justice Krishna Kumar, Justice Shishananda and Justice Poonacha for their unwavering support. To the Honorable Members of the Board of Governors of the Arbitration and Conciliation Center, Justice Magdum, Justice Natraj, Justice Indresh and Justice Uma, thank you so much for helping us shape the discourse for this past weekend. We're also thankful for the cooperation and support of sitting and retired High Court judges of the Honorable Supreme Court and the Honorable High Court of Karnataka for their involvement and their commitment to the initiatives of the bar and for accepting our invitation to be a part of this weekend. Justice Ravindran, who is truly a giant in the field, thank you, sir, for leading the arbitration interactive sessions and for that insightful address. Thank you to all the panelists who shared their thoughts on a wide range of topics we've had the privilege of witnessing. They've really given us a lot to think about now. And we're indebted to the Arbitration and Conciliation Center for their support of this event and dedication for the promotion of ADR in Bangalore, and the Karnataka Judicial Academy for hosting the event with impeccable hospitality. The Director of the Arbitration Center, Mr. Dinesh Hegde, along with Deputy Directors Vignesh and Mr. Alok, the Director of the Karnataka Judicial Academy, Srimati H.R. Radha, Deputy Director, Mr. Sharat Chandra. You've been an integral part of the team throughout from start to finish, and we've really enjoyed working with you. A special and personal thank you from all of us on the organizing committee. We thank our district judges and civil judges and the arbitrators who've joined us from across the state and who promote and strengthen our arbitration and mediation in Karnataka on a daily basis. This event would not have been possible without the enthusiastic Advocates Association and the Bengaluru Bar, who have turned up in numbers to participate in the event. We look forward to working with all of you to augment the arbitration ecosystem, which was the theme for this weekend. Thank you to all our friends from the bar who've supported the event financially. We also thank senior advocates Dhyan Chinnappa and C.K. Nandakumar for their acts of support. And of course, Mr. Arun Kumar for his bare act of support. He's donated these bare acts for all the junior members of our bar. If you've not yet picked it up, there are a few here that you can grab. The members of the organizing committee, team of 10 lawyers who put aside time in their already busy schedules to create this platform, sharing ideas and thoughts. A platform which is aimed towards working together in this long-term project of making arbitration in Bangalore more effective and efficacious. Thank you all very much. We appreciate the support staff, event manager, administration teams, coordinators, technical teams who did the hard and heavy work that made this run so smoothly. We've had an incredible team of advocate and student volunteers who worked literally around the clock. It's been a high-stress period for them and a gargantuan effort. Thank you very much. And with deep respect and sincere appreciation, I thank you all for your participation. Thank you.
Thank you, Pradeep. May I request everyone to rise for the national anthem?
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
On behalf of the Bengaluru ADR Week Organizing Committee, we thank you once again for being here today and wish you a restful Sunday ahead. Please join us for lunch on the first floor. I request everyone to remain standing as the dignitaries leave the auditorium.